All right, it looks like we've got a good amount of people who've jumped in so far. So I'm happy to get started. Ladies and gentlemen, a very warm welcome to you all. We appreciate your time today and we'll do our best today to shed some light on the best practice ways in which we can manage difficult employees. I'm sure throughout the presentation you'll have some questions, but we'll go through them at the end of the webinar, but I highly urge you to use the Q&A function near the bottom of your screen. That way we can actually answer some of your questions. So as you can see from our title, how to manage difficult employees, we picked today's topic. As I mentioned earlier, it's one that's always in high demand on our advisory line, especially as it can sometimes feel like a minefield around what you can and can't do when you do have a difficult employee. It is difficult to know what best practice steps you're meant to follow with our legislation. And on the other end of the spectrum, sometimes I speak to businesses where they're not really sure what they need to do or what the process even are. They might even think it's easy to handle a difficult employee. So yeah, today we want to make sure that we're giving you the right information so you can make sure you're protected. So hopefully today we can address any questions or doubts you have around managing difficult employees and make sure you're as informed as possible after today's session. Before we get started though, I'd like to introduce you to today's speakers. At the top, you'll see we're lucky enough to have Law present today's information and answer your questions. Law is one of our very own, very knowledgeable senior workplace relations consultants. She's a core member of our advisory service. So today she'll be walking you through today's topic and guide us through on how we can actually manage difficult employees. Below her, you'll find myself. My name's Anu. I am a business development coordinator for HR Assured, but there's also another introduction I'd like to make. So for those of you who aren't familiar with our group or our family, on your screen are all the current members of the FCB family. There might even be some new names in there that you might not have seen before as well. So we'll start at the top left. We have FCB Workplace Law. They're one of the leading specialist employment law firms within Australia. FCB Workplace Law has been in the industry for 30 years now. They're pretty much the backbone of where we get our expertise in employment law. Next to that, you'll see FCB Smart Visa, which is our immigration and migration practice. We'll jump to the bottom left. We have Enable HR, which is our in-house proprietary technology solution. It exists basically to help you manage your HR and your health and safety on a cloud-based system. Now, it helps make managing workers less complicated and easier to do. Enable HR is a bit more unique than other systems. It's been built and maintained by FCB Workplace Law, so it's really excellent at keeping or helping businesses manage their compliance and follow best practice. As you know, the bottom right, those are maybe new companies that people are less familiar with. They basically exist to help businesses around ISO certification, but also NDIS through QMS. So if you need assistance around those, you can reach out to them as well. But the banner in which we're talking to you today is HR Assured. So HR Assured is your external HR and health and safety partner for your business. So the whole slogan's always been avoid admin and create the culture. That's one of the ways in which we best support businesses. So most of you who are here probably have some sort of responsibility around the HR or health and safety side of the business. And we understand a lot of you probably don't want to spend as much time ensuring that you're meeting all the legislative requirements of managing employees and doing all the admin that comes along with that. So HR Assured exists to take as much of that work off your hands as possible so you can better spend more of your time on things more impactful to the business. So like your business strategy and your company culture. So how we do this, when a client first comes on board, the first thing we do is we do a comprehensive HR audit. This is to help diagnose the parts of the organization that need assistance. From there, any critical areas of non-compliance, we'll jump onto that straight away. Then we'll work with you to plug in the holes that we've identified to ensure that the business is following best practice. You also have unlimited access to our advisors. They're always available to you at your fingertips so that if you ever find yourself in a tricky situation, you'll have someone to turn to and help you navigate through it. We also give you access to our cloud-based software to help you make things less complicated and easier to manage in the business. And it'll also give you access to legal resources from our law firm, and those are constantly updated as well. Quite importantly, you also have access to our Advice Promise. This is a protection mechanism in the event you ever receive an employment-related claim from an employee. As everyone's aware, sometimes, no matter what you've done to manage the particular scenario to the best of your ability, sometimes it can still result in a claim, even though you've done the right steps. So the advice promise is there to help you. So in the case you have to defend it, which can end up being costly and frustrating, our advice promise means that if you do receive a claim, we will stand beside you, representing you in court if needed, and even paying out costs associated with the claim for you. So all of that is included in a low monthly cost. So do reach out to me if that's something that you guys want to look into for your business. But with that in mind, I would like to hand over to Law to take us through today's agenda. Over to you, Law.
Thanks so much for that introduction, Anu, and for that very informative piece around how our business operates for our viewers today. Just before we dive in, I'd like to do a little shout out to my mum, who I know is in the webinar audience today. Thanks, Mum, for joining. But look, we're going to be addressing the underlying issues that may lead to poor performance, how to undertake a performance management and disciplinary process, what to do when performance doesn't improve, what happens if you ignore performance or conduct issues, and at the end there's going to be an opportunity to be asking and having your questions answered. So comparing performance management and the disciplinary process. So here you'll see on the screen, we do have performance management and conduct issues separately identified. They are two distinct issues. Performance management is an effective tool to engage employees when they're not meeting workplace expectations. Poor performance could specifically be in relation to the quality, quantity, or efficiency of work that is produced, as opposed to conduct issues. So these may include, for example, breaches of the workplace employment policies or rules. The significance of the conduct concerns can, of course, vary. So you may have serious misconduct, which can involve criminal or fraudulent behaviour. Employers are always encouraged to formally address conduct concerns. So let's take a deeper dive into performance management. Underlying issues that lead to poor performance. Sometimes unsatisfactory performance is identified where there's a disparity between the actual and expected performance outcomes. Some of those underlying causes of poor performance can include those from both an employee perspective and employer perspective, and they may be different. So from an employee perspective, we have things like a lack of knowledge or awareness, inadequate skill and experience, personal problems or issues that are external to the workplace, capacity. We have conflicts in the workplace. We've got perceptions of fairness and equity, motivation, and a lack of or unclear performance goals, measures, or priorities. On the other foot, from an employer perspective, we may have issues such as unrealistic expectations around performance, a lack of supervision or training, insufficient or inadequate resources, a lack of leadership, direction, or instruction, pressure on leaders, and culture and values. So we have some performance management objectives in the workplace. This much is clear. We would like to improve performance outcomes. We would like fair and effective appraisal of performance. Ideally, we will identify training and development needs, and we will improve behaviour, which is going to be essentially the conduct of our employees in the workplace. Identify barriers to performance, facilitate good employee relations, and repair employee relationships. All of these things are going to contribute to better performance of our employees. So, a performance management roadmap. Where do we start with this roadmap? The first step is going to be identifying what is causing the employee to underperform in the first place. Pinpointing the root cause of this underperformance is essential before we start implementing strategies to try and assist the improved performance. So that's where I was talking about just before. We have those possible reasons from an employee and employer perspective around why there might be poor performance. We need to be looking at those and working out what we think applies in this particular situation. So then how can our employees' poor performance be categorized? So that means, is it going going to be related to maybe capability. Is it capacity? Are there behavioural concerns? It's about digging a little bit deeper into why this issue is occurring. So with capability, we're looking at things like, does the employee have the skills to do the role? Do they have the requisite experience to be performing at the level that we need? And do they have the behavioural competency? So this is looking at things like communication skills. In respective capacity, we're looking at things like, are they available to perform the hours that we need them to perform in their job? Do they have the physical and psychological capacity? And do they have the resources to perform the role? Behaviourally, we're looking at things like attitude, motivation, conduct, and confidence. And these are things that can be both internally and externally motivated in relation to individual employees. Now, as a part of this performance management roadmap, we do need to start somewhere. And as part of that initial preparation phase, we need to look at any other factors that are contributing to an employee's poor performance, which might be informing why we have this issue and how we need to respond. So we need to consider things like personal circumstances. Everybody has a life at home. What's happening in that individual's life that might be affecting their poor performance, and do we know about it? Are there any conflicts or grievances or bullying and harassment that might be occurring that might be impacting this person's performance? Or other factors might include, for example, leadership, management, or peer-related issues, whether or not that's in the workplace or not. What outcome is then the outcome that we'd like to achieve in this process? And whilst we're not saying here that you should be coming into this with a preconceived idea of the outcome of the performance management process, we are saying that it is good to identify, based on what the issues are and the implicating factors, what kind of outcome we're looking at achieving here. Are we essentially going to undertake this process of performance management to improve their performance? Are we going to take this process with a view to kind of enforcing a better compliance by this individual of their performance requirements or obligations? Or are we going to take this approach with a view to essentially terminating the individual? And that might be for reasons like, we've had other issues with this person before, this isn't the first time we've tried to performance manage them, and now their time has potentially come to an end in the business. So when we're looking at our possible solutions, we do have different options. One of those is performance counselling. And this means engaging with an employee in a performance counselling session for the purpose of effectively achieving some of the dot points that are identified on our screen here. So you might be addressing less significant behavioural concerns like possible breaches of a company policy. You might be trying to work alongside the employee to foster improvement and learning. So in a conversational setting where you're talking about maybe some concerns and you're talking about what it is that you'd like to see that might be different. And by the kind of tone that I'm imposing here, it's to say that this is not a punishment. This is an opportunity here to talk about how we grow from what we're identifying as not exactly the way we need it to be. Giving employees the opportunity to discuss their reasoning, providing additional context to their situation, and raising any barriers that could be impacting performance. Effective prompts for employees in these conversations can include kind of open questions like, why did you ABC? Why did you engage in that kind of behavior when you've identified to me that you know it might not have been the right approach to take, for example? Or from your perspective, what happened on that day? Or, for example, what prevented you in that situation from maybe saying what you've just suggested you might have said instead? Prompting questions like that can assist to kind of draw out the reasoning and the context which informs why the person behaved the way they did. We can also use this performance counselling approach for determining whether the employee was solely or partly responsible for any concern that we've identified. And if there were others involved, do we need to have a chat with them too? In terms of that deeper question of fault versus responsibility, we can look at questions of, did the employee have the resources to meet their performance expectation or deliverables? Did the employee rather rely on someone else or something else, which has resulted in this performance outcome? And was the outcome essentially within the employee's control? And these are all questions that we need to be asking, bigger picture questions in this performance counselling process to kind of nut out what has been the root cause of this performance concern. Finally, we have there listed determining whether the performance expectation was realistic. So that's looking at the question of, did the employee actually have the knowledge or awareness in relation to the concern that's been identified? Or did the employee have or claim to have the skills or experience? We want to make sure that people are equipped with the skills in their roles to do what is required of them. And if they're not, maybe there's a gap from the employer end of things that can be improved. And that's the purpose of this conversation, is to nut all of that out. So other than performance counselling, there is an alternative approach to performance management, which you may have heard of. It's called a performance improvement plan, or a PIP. This can be a great tool to implement when a business wants to formally address and work towards improving employee conduct. So there are on the screen some things that need to be considered before implementing a PIP. And these include, is there an actual performance issue that can be substantiated? Management should be able to list the deficiencies, including dates, specific data, and any previous reviews, for example, in relation to poor performance. And this is relevant in my experience. If you're not going to identify sufficient details in a PIP, the employee may struggle to respond with sufficient detail. So we need to start on a strong foot. Is the employee's manager committed to assisting the employee? And this goes back to the question I noted before of, are we coming into the process with a preconceived idea of how this is going to resolve, or are we coming into it with the objective of offering a genuine opportunity for performance improvement? Is it likely that the issue can be fixed through a formal improvement plan? So looking at how realistic or appropriate this approach is going to be for the actual issue. Problems with sales goals, quality ratings, quantity objectives, and similar issues may be well suited to a structured plan that helps identify why deficiencies occur, but insubordinate or insolent behaviours, for example, may not lend themselves to improvement using this quite goal-oriented process. We also have identified the question of whether it appears the employee has received proper training or succeed at their task. If the employee has been absent or is new, they may not have received all of the right training, and this needs to be explored through a personal or a performance improvement plan to make it a fair one that is realistically achievable. Finally, we've listed, is there a known personal issue that may be affecting the employee's performance? Again, this is going to implicate the reason why a person has had performance issues in the first place, or it may implicate it, and it can affect the way we proceed to manage their performance moving forward. So what do we include in a PIP? Great question. Information on what acceptable performance levels are and how the employee's current performance is deficient. Again, this is going back to being specific with identifying what it is that we're not seeing and what it is that we would like to see in sufficient detail such that the employee can meet us with that performance. So specific and measurable objectives that are achievable, relevant, and time-bound, which the acronym there is SMART goals. PIPs usually last for about 30, 60, or 90 days. And that's a broad statement of what they will usually do, depending on how long it reasonably takes, or it should take, for the improvement of a specific issue. That is not a hard and fast rule. That is flexible based on the circumstances. And it's something that an employer can decide on a case-by-case basis. We also want to include guidance in that PIP on what management will do or the support they'll provide to assist an employee to achieve their goals, such as additional resources, training, or coaching. There needs to be, in addition, details on how often the manager and employee will check in to discuss progress. So these are just regular check-in meetings, and you might schedule them or you might have them ad hoc. This is often done once a week, but it can vary depending on the circumstances. We also importantly need to say in this PIP what the consequences will or may be if we don't see the satisfaction of that PIP and meeting of those objectives. This is important. It's not only going to be a key motivator to why we want to see improvement for the individual who doesn't want to essentially meet those disciplinary outcomes, but it's also an important process and an important it's an important part in backing up the employer's process in the event that there may be some conflict down the line. Now, this leads us to our disciplinary processes. A disciplinary process is generally used where an employee has engaged in misconduct. So, serious misconduct is categorized as behavior that is sufficiently serious that it may cause damage or will cause damage to other employees or to the business, and it involves breaches of policies and procedures. Disciplinary processes need to be acted upon quickly in order to address the concerns and reaffirm the employer's expectations. They may require the employer to undertake a formal investigation or a fact-finding process before we reach an outcome, and this can include interviewing other parties, for example. In many cases, the outcome will be a warning of some sort, which should always be reflected in writing, or in some cases, if the conduct is particularly serious, it may result in a termination. I will also note here that it is commonplace for, and we suggest that employers use a policy to reflect their disciplinary processes. This is not only good for the uniformity of approach by an employer, but it helps for employees to understand what they can expect from their employer if they're going to engage in misconduct. So where conduct concern arises, it's important that an employer is going to determine what is the nature of the conduct. So is it misconduct? Is it just inappropriate conduct? Is it a blatant, intentional breach of policy? Does it require the employer to undertake an investigation? So do we know all of the information that we need to make a decision about disciplinary action? Or have we got gaps in our knowledge? Do we need to go and ask some more questions? Inform the employee of the concerns and invite them to a disciplinary meeting. We always advise our clients that we are giving individuals at least 24 hours of notice and the opportunity to bring a support person to a meeting for the purposes of discussing disciplinary issues. This is done in the interests of fairness to an individual and to provide them with a reasonable opportunity to be processing the matter which is presented to them, which ordinarily, and as we all know, can incite some stress. We also we also advise employers determine that the conduct, we always suggest that employers are conducting the meeting and considering the employer's responses in a genuine fashion. So not just lip service in terms of what are your concerns, all right, I've noted them down, we'll move to termination now. Rather, talk to us about your concerns. We've raised ours. What have you got to add to this picture? We make notes of that and we genuinely take it into account in formulating our response. That is where we make a decision on the outcome and we follow that up in writing. Oftentimes, we suggest that people do reflect part of that consultation with the individual in their writing to indicate that they've taken it genuinely into account. And at this point, I believe we're going to take a little break, so I will hand back to Anu.
Thanks, Laura. Now, I know we've covered a lot of quality content already. I can see a few questions have come through as well, which is really great. We'll cover off as much of these questions as possible at the end, but in case we don't cover all of your questions, or if you have something more sensitive that you want to discuss more specifically, then feel free to pull out your phone and scan this QR code. This will give you a chance to conduct a complimentary workplace compliance consultation with one of our colleagues. We can discuss with you in that consultation the topics related not only to this webinar, but about you and your business. So if you haven't had anyone external even to have that discussion with, or even if you're not really sure what you have in place and if it meets the requirements, this will be perfect for you. We can help talk about your current setup with your current contracts, your policies, your HR management systems, as well as any other potential employee issues you might have dealt with in the past or even present that you want some more information around to be better informed with your decision making. As you know, it is the duty of the business to ensure that it is fully aligned with the regulators, but we see it as our duty to help you actually achieve that. So there's no obligations to this workplace compliance consultation. So hopefully it's a win-win situation for you. And if you can't scan it, there is a little link just below. So I'll give you a minute to, so you have enough time to scan it. But yeah, make sure we make use of that as well. All right, hopefully that was long enough for you guys to scan the code. Yeah, that's it from me. We'll bring it back over to you, Law.
Thanks, Anu. That was a nice little rest break for me. So we will continue on with the question of what happens if performance doesn't improve. And I don't know that we've all experienced this, but hopefully we haven't, but it can happen. So we always say that you need to look at your options when this occurs. If an employee's performance is not improving after a reasonable period of time, and then it will change depending on the circumstances, and the business is engaged in a PIP, you may need to consider what other options that you have. So should the performance improvement plan continue? If the employee has shown some slight improvement, but not yet the full extent of what their improvement objectives are, you can extend the PIP, and this can be beneficial. Of course, you should be making a case-by-case assessment of whether or not it's appropriate, whether we think it's going to be beneficial and why. But importantly, it is an employer-driven process, and you don't require an employee's agreement to be extending a PIP. We do, however, suggest that it is a reasonable change. We like to assess employee engagement where this question arises too. And this is important because if someone is happy in their current role, they may be open to an alternative role within the business where the employee could be transferred, or they may be more satisfied in that alternative position and they may perform better. And we want to be considering this option rather than exiting an individual from the business. We do, however, invite consideration of dismissal. It may be appropriate in some circumstances. Employers need to ensure that any reasoning to terminate is not unjust and it's not unreasonable. We need to provide employees with written reasons why their performance may result in termination. We need to reflect on the tools that the employee has been provided with to help them improve. And we also suggest always consulting with an HR advisor because the circumstances can be very variable. There may be a complex history of managing poor performance with an individual. There may also be complex factors affecting the situation, such as protected grounds of discrimination. And we always want to assist where we can to minimize any risk involved with that process. So what happens if you get it wrong? It does happen. Or maybe you didn't get it wrong, but somebody made a claim anyway. So the risks if you get it wrong. Having a performance discussion or conducting a disciplinary meeting, which as I alluded to before, it can be quite confronting, challenging, and even uncomfortable, especially if you're dealing with a difficult employee. Some people particularly don't like confrontation, and this can be quite confrontational as a process. Importantly, managers should be well versed in how to conduct this process and how to de-escalate upset employees to avoid risks eventuating. Some of these risks do include what we commonly see as an unfair dismissal claim, general protections claims such as adverse action, which you may have heard of, discrimination claims, workers' compensation, which is your stress, kind of work-related stress claims, and bullying and harassment claims. Unfair dismissal. This is something that occurs when there are procedural deficiencies in a termination of employment, such as failing to give an employee an opportunity to respond to any reason presented to them for dismissal relating to their capacity or conduct. In addition, procedural deficiencies may include an unreasonable refusal by the employer to allow an employee to have a support person present to assist in any discussions relating to a dismissal. You may also find with these claims the issue of failing to warn the employee about their unsatisfactory performance before the dismissal. So basically going in cold and saying, we're not happy, see you later. Then there is also your typical kind of flawed investigation. You haven't maybe had procedural fairness. Perhaps things have taken far too long and you've ended up in a termination process that wasn't necessarily justified given the amount of time it took. Maybe someone wasn't given the right, the correct detail or the amount of information they needed to participate fairly in the process. All of these things can contribute to the risk of an unfair dismissal claim. Importantly, there needs to be a valid reason for termination. This is legislated. This is under Section 387A of the Fair Work Act, where it says that in considering whether it is satisfied that a dismissal is harsh, unjust, or unreasonable, the Fair Work Commission must take into account whether there was a valid reason for the dismissal related to the person's capacity or conduct, including its effect on the safety and welfare of the employees, of other employees. Mandatory criteria which needs to be considered in answering this question is, was the reason for termination sound, defensible, or well-founded? These are part of the valid reason. In addition, it's not going to be enough to say that an employer believed the termination was for a valid reason. And that is going to always turn on the circumstances of a particular case. And again, that is where we have value in seeking HR advice in any circumstance where we're looking at terminating somebody to make sure that we're crossing our T's and dotting our I's. Now, again, under Section 387 of the Fair Work Act, in considering whether the Fair Work Commission is satisfied that a dismissal was harsh, unjust, or unreasonable, it needs to take into account whether a person was given notification of the reason for the dismissal and whether they were given an opportunity to respond to any reason related to their capacity or conduct. It needs to be satisfied. Rather, it needs to take into account, in addition, any unreasonable refusal by the employer to allow the person to have a support person present to assist in any discussions relating to dismissal. Now, that is a great point, and there's much to be said, and I won't delve into it in this webinar, but there is much to be said about questions of support persons and who's an appropriate person to have and what kind of role they can have. I'll just leave that thought with you. In addition, the Fair Work Commission needs to take into account if the dismissal related to unsatisfactory performance by the person, whether the person had been warned about that unsatisfactory performance before the dismissal. Now, general protections claims, I before mentioned to you one of the most common of those, which is your adverse action claim. A person must not take an adverse action claim, or must not take an adverse action rather, against another person because the other person has a workplace right, has or has not exercised that workplace right, proposes or proposes not to exercise a workplace right, or to prevent the exercise of a workplace right by another person. Now, that is just a beautiful example of some great legislative drafting, but essentially it's a very broad definition. So there can be risk with adverse action where you don't even suspect it. An employer takes adverse action against an employee if they dismiss the employee or injure the employee in his or her or their employment, if they alter the position of the employee to the employer's prejudice, or if they discriminate between the employee and other employees of the employer. So it's quite broad sweeping, and there can be different circumstances where you may need to check to see whether you think there's any capture under these terms. Now, common employer action where we are seeing these risks of general protections are relating to performance management and disciplinary meetings. The typical employee responses where we see these risks of adverse action are in relation to the workplace rights listed on your screen there. So you've got workers' compensation, taking personal leave, making a complaint to the employer. That's something we often see is maybe there's a complaint that's been made and we don't necessarily, there's questions around whether it's a valid or legitimate complaint. We think maybe an employee is stirring the pot, and then in response, somebody says, we just want to get rid of them. Alarm bells can go off there. In addition, your workplace rights include exercising union or industrial rights, or lodging a bullying claim in the Fair Work Commission. And that is not an exhaustive list. So there is a lot more to that picture, just letting you know. With workers' compensation, it's commonplace for employees to argue that a performance management process or a disciplinary process has caused them a psychological injury or stress, resulting in them making a claim for workers' compensation. Importantly, the psychological injury needs to have been caused or aggravated by work for the employee to be eligible to make a workers' compensation stress claim. The risk can be exacerbated if the employer has not followed due process or has been harsh in their approach, and that is where it can be important to get some advice in relation to the steps that you take, and it's certainly not our advice that you take the same approach for every individual. Each state or territory also has different workers' compensation legislation, just to make things easier for you if you have, for example, business running in different states. In New South Wales, the relevant act states that no compensation will be payable under this relevant act if the injury was wholly or predominantly caused by reasonable action taken or proposed to be taken by or on behalf of the employer with respect to transfer, demotion, promotion, performance appraisal, discipline, retrenchment or dismissal of workers, or provision of employment benefits to workers. In respect of the discrimination risk, in some cases, performance management or counselling processes can uncover more than an employer bargained for, such as an employee informing them that they essentially have a disability or some other protected attribute that has led to or contributed to the poor performance or conduct. Just flagging here, sometimes we have people call up with questions around, I don't know whether or not it's a legitimate claim that this person says they're affected in this way by a particular thing. That's a common question, and it's a valid question, and that's part of what we're here for. An example here, which is on your screen, is where a manager commences a performance counselling process and asks the employee why they haven't been meeting a target. And the employee says they're finding it hard to concentrate because they have a mental health thing going on. At this point, the employer needs to ensure that it's getting more information about this issue before taking further steps, because not doing that can lead down the risk of a discrimination or general protections claim. Now, to clarify here, discrimination operates within the banner of general protections, and it also operates independently of general protections claims. So there can be two separate arrangements there. Another example would be attempting to discipline an employee who's behaved aggressively, and then they divulge that they were experiencing perhaps a psychotic episode at the time. Again, further information needs to be sought so that we can avoid disciplining an employee for actions which can be clearly or not clearly, but attributed essentially to having that mental illness. Now, bullying and harassment. We also see many employees claiming bullying or harassment when their employer seeks to undertake a formal process with them. People don't like being subjected to formal processes in the workplace, we have discovered. Now, under the Fair Work Act, there's an exception for reasonable management action that is carried out in a reasonable manner. So this is intended to acknowledge that, and it's listed on the screen there, I'll give you the brief, but persons conducting a business or undertaking. Now that's a definition that refers broadly to persons operating business. So not just employers, but people running business, they have rights and obligations to take appropriate management action and make appropriate management decisions. They need to be able to make necessary decisions to respond to poor performance, or if necessary, take disciplinary action, and also effectively direct and control the way work is carried out. Now, examples of reasonable management action can include a performance appraisal or ongoing meetings to address underperformance, setting reasonable performance improvement goals, or disciplining a worker for misconduct. In saying that, there are always nuances to these approaches according to particular circumstances, and it can be very worthwhile getting assistance or advice to clarify if the performance management or management action that you're considering taking is the right approach in your circumstances. So we have compiled some tips and tricks which we think might be helpful to our viewers today in relation to managing our difficult employees. Firstly, importantly, formal documentation is crucial, and this is speaking to the issue of when someone calls up and says, I gave them warnings and so on and so forth, but I never wrote anything down. Maybe you know someone who's done that, or maybe you've done that. But documenting these processes is crucial to protecting your business against the risks that I've just talked about. Detailed evidence of the lawful objective reasons for actions to substantiate the business's actions. So this is talking again or partly to documenting the process, but also backing yourself up, backing up the steps you've taken and the reasons you've taken and why you've taken those steps rather. Ensure that you have an uncompromised, impartial decision maker. If a complaint, for example, is raised about a particular person in the business, that person shouldn't be the one investigating the complaint. Make sure your employment contracts are up to date and that they have express provisions in them around misconduct. You don't want to get caught in a situation where you're not sure if it's misconduct, but you're feeling quite aggrieved and the contract doesn't say anything about what is misconduct. Design and implement clear policies and procedures, particularly in relation to bullying, harassment, equal opportunity, and the handling of workplace grievances. And this speaks to, which I think I mentioned before, the value of documenting processes for both employers in terms of the uniformity of their approach, and employees in terms of giving them access to information about how this workplace runs and what might happen if they do engage in bullying, for example. Then we also suggest a sneaky little tip: seek advice from an HR advisor before you make any firm decisions, or particularly in circumstances that may be complex or you just don't know because maybe you've been dealt a curveball. And be measured. That's not to say take as long as you like. It's important to act in a timely manner in these situations, but don't rush. Make sure you're taking a measured approach and make sure you're giving due time to preparing yourself so that you're taking the best steps possible in the best possible way. In addition, how you're going to frame the issue to an employee is key in managing a difficult employee. You always suggest you always want to be approaching a situation from a positive angle. So we've noticed these issues and we want to work with you to facilitate improvement with these issues. Or we're able to support your improvement by providing you with coaching. Is there anything additional that you think the business could do to support you to get these changes over the line? Are there any barriers preventing you from improving in these areas that you might want to discuss with us further? These are examples of the types of language or sentences that we suggest people take to deal with their situations. And we suggest as well that you're avoiding absolutes such as, the reality of this situation is you did the wrong thing and da 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 da. Because this is demonstrating essentially a closed-minded or a closed-off point of view where you're not willing to consider any other alternatives. Part of this is inviting other opinions or views. So the purpose of this being that you're going to have, or you want to achieve or facilitate, a healthy dialogue and understand the best option by gathering all of your information. And by taking this approach, we want the individual to feel that that is what you're trying to achieve as well. It's not just about your intention, it's about the way they receive your intention. And I think that brings us back to Anu, and perhaps question time eventually, I think.
Soon, very soon.
Okay.
But thank you for that. Was very informative.
Thank you.
But yes, before questions, just jumping in very quickly, just to remind you about the QR code again, just in case you weren't able to do it earlier. Maybe you just heard a few things from Law just now that made you feel like maybe I do need a third party to help me see where I stand right now, because there was a lot of really good information just then. So again, just to recap, this complimentary workplace compliance consultation is designed to help you go through some of your key risks and threats to the business and help you understand what we need to do to ensure that we're compliant with the current complex laws in Australia. So we can confidently say that the consultation is a very good opportunity to identify those risks and threats in the business and give you some direction around how you can identify those unnecessary risks in the business. So for example, a really hot topic I get on the phone a lot is the Secure Jobs Better Pay bill that came out very recently with massive changes. The consultation is a great chance to ask questions around that, for example, or anything else that you just haven't had any certainty around, and we can help you make sure you're compliant. So I'll give you another minute to scan this QR code, and then we'll jump into questions. All right, that should be all good. Let's jump into some of your questions. We'll get through as many of these as we can. I'll make sure I won't be reading out any names, so don't need to worry about confidentiality, but I'm definitely conscious of time. So, but if we can't get through your question today, I definitely recommend using that QR code to, you get access to our team and we can see how we can help you. But yeah, hopefully we can give you those insights as well. So we'll go to question 1. I have an employee who is combative when I ask them to do particular tasks that are part of their role. I've tried to support them and understand why they do not want to do these tasks. They're really good at their role in other areas. What are my next steps? Law?
Thanks, Anu. That's a really good question, and it's something that I see a lot of in the telephone advisory service. So you're on one hand, you want to celebrate the fact that this individual is perhaps a strong performer in some ways, but on the other hand, they are maybe belligerent in other respects. Let's just use an example of maybe a receptionist. If you need to answer phones and deal with the mail register on a day-to-day basis, plus everything else, but you just don't like dealing with the mail register, and so you refuse to do it. The position that we generally take on this is that it's actually you're failing to, or you're not performing the inherent requirements of your role. Now, you can address this as an underperformance or a misconduct issue, in that the individual is making a decision not to do the work that they've been hired to do, that they've agreed to do under their contract of employment. So you can engage in a performance management process with this individual. And like I said during the webinar, it's an employer-driven process. So they're not going to like it and they're not going to necessarily agree, but you can start a process of talking to them about their concerns with them not performing the parts of their role that they're required to perform. And pending how that goes, you can lead into potentially a disciplinary process.
All right, thanks, Law.
That's all right.
Next question. Is there an issue if I use performance management processes for misconduct?
Look, like I've been saying throughout, there you can do different things for different issues. But you're saying here, is there an issue using performance management processes for misconduct? The answer is that performance management processes are really geared towards making an improvement, if I can use kind of a metaphor, improvement might exist on a grey scale. So we've got black at this end and we've got white at this end, and there's a bit of grey in the middle. And improvement in performance is going to be a process of gradually improving up to the point where we want to be, versus misconduct, which is I'm doing this behaviour and I shouldn't be, I should be doing this behaviour. It's a little bit more objective in that sense. So generally, we would advise against using a misconduct, like a disciplinary process for misconduct, where there's a performance issue and vice versa, because it's not really tailored at the type of change that we want to see from an employee. It may also create risk in terms of misusing or inappropriately or unreasonably using something which might be considered a harsh approach for a particular issue. There's lots to be said about that. It's a very broad question.
Thank you. I have an employee who is struggling with mental health, but they are not performing to the standard that's required. I know that I can't fire them for this, but what other options do I have?
There's also something that's very relevant, having come out of the, if dare I say, we're in the post-pandemic era, and a lot of people in the workplace are experiencing mental health concerns. So certainly we suggest that people aren't taking a point blank approach of, you're not doing what I need you to do, see you later. That does carry some significant risk with it. Depending on an employer's relationship with an employee, we might suggest, if you have a positive relationship, that you're having a sit down chat and going, foremost, let's have a welfare chat. I know I have some, I know that you have disclosed to me A, B, and C in relation to your health. And as your employer, I want to make sure that I'm providing the support to you that you need, the best that I can, so that you can do the best that you can do in your role and that you're happy and healthy at work. It feeds right into the work health and safety obligation as well. So we use that welfare conversation usually as a kind of primary approach or a first step so that we can inform our approach after that. So once we have that chat, we come to understanding more about this health condition that this employer has told us about, maybe how long it's been going on, whether they have a regular treating practitioner, how it might affect them in their day-to-day in their role. And having this information is really, it's a toolkit to help us to know what to do next and how to do it to minimize risk. If we can separate concerns in relation to work from a mental health consideration or issue, so that it's, the performance issue isn't attributed directly to a mental health issue, then we might be able to take an approach of more formally going down that performance management pathway with less risk in relation to perhaps discrimination on the basis of disability, for example. But it's all going to turn on the circumstances, the relationship between the employer and employee, what we know about this individual's mental health factor, how long we've known about it, and so on and so forth. It's yeah.
That's a good question.
It is. Relevant. It really opens up a can of worms.
Perfect. I've got a question here. Does HR Assured provide PIP templates and documents? I can answer that one. We do have performance improvement plan templates as part of our service. They're actually available on our HR system. So HR Assured Cloud, which all of our clients have access to, has a library of documents built in. So it's a big suite of documents available for our clients, and part of that is a performance improvement plan. But there's a whole list of templates and documents that you'll have access to. Yeah. I'll jump to the next question, probably the last one from us today, just going off the time. I've heard of providing coaching for performance management issues to employees is the same as counseling.
Have you? Well, I guess, is this question asking for kind of a differentiation between the two? Or because I guess, assuming that's what we're getting at, it's not the same, but it can be. I think often people think it might be the same. And I know that in our slides, we kind of mentioned coaching. We were talking more about counselling though. They are not the same. It's kind of like the difference between using performance management processes for performance concerns versus disciplinary processes for conduct concerns. There can be a pretty minute difference depending on what the issue is that we're dealing with. So coaching, for example, is meant to be it's a system of engagement with an individual to give them the tools to grow in a particular way, to motivate them to improve their performance. And it's not necessarily coming off the back of identifying an issue. It can be you're doing well in your job, and we have access that we can give you to coaching, which is going to develop something you've identified. For example, if you go through your annual performance review, you might say to your management, I have the goal of improving my public speaking skills. So you don't necessarily have to have an issue with your public speaking skills to go through coaching, but the coaching can actually build up on that skill. Whereas counselling, you're kind of starting from a position of having identified something that you want to address. And the counselling is geared at or focused, targeted at addressing that particular concern. And depending on the nature of the issue, you can use particular trained professionals for either the coaching or the counselling, or you can just use an HR professional who's maybe undertaken some training themselves. But they are different. They do serve different purposes. However, I recognise that they can be quite easy to confuse. Yeah.
Perfect. Thanks, Laura. Well, yeah, definitely that would be time for us today. So that would be it. Thank you so much for spending some time with us again to watch this webinar. We hope you took advantage of the initiatives that we're offering, but more importantly, we hope you walked away with some information that's really valuable to you. We do these types of webinars regularly, so keep a lookout for our next one. And yeah, we'll definitely be in contact with you soon as well to check in. So yeah, take care, stay safe, and yeah, hope you enjoy the rest of your day. Thanks.
Thanks, everyone.